Good morning. Welcome to another edition of Legal Access brought to you by the McGuire Law Firm. Today we're going to be talking about criminal law. If you have any questions about drug arrest, DUI arrest, any kind of arrest, maybe the court system, plea bargains, any kind of question you have regarding that on the prosecution or the defense, we'll be able to answer those for you here today. Phone number's on your screen. Give us a call. We'll get you on the air, but don't wait till the very last minute. We want to hear from you whenever you can. Give us a call, 848-8080, right here on Legal Access. On the panel to answer the questions here for you today, from the prosecution side, first of all, from the 15th Circuit Solicitor's Office, which covers Horry and Georgetown County, got Josh Holford. Hey, Josh, good to have you back.
Yeah, thanks for having me, Dave.
And from the defense side, to your left, we have two great attorneys, Greg McCollum. And Greg, tell us a little bit about your firm and what you all cover besides criminal defense.
We don't cover anything except criminal defense.
Okay.
That's all we do. Our name of our firm is Complete Legal Defense Team. And interestingly, most of our clients have never been arrested before. That's really the people that contact us the most. And we say we defend the accused who have a lot to lose. And another person that I know had said that my law firm doesn't represent criminals, we represent people who get in trouble.
All righty. And to your left, Kirk Truslow is back as well. And Kirk,
Dave.
your firm, and what else do you guys cover besides criminal defense?
We just practice criminal defense work as well. And I think actually probably Greg and I are the only firms in this area that exclusively do criminal defense work, as far as I know.
All right, well, there you have it. That's our panel. Give us a call. It's 843-848-8080. We'd love to get you on the air, as criminal law is our topic here today on Legal Access. Let's go ahead and start with a roundtable here. Now, what's easier, to get 12 people to agree to convict somebody, or to get one person to agree that you haven't met the bar?
I think getting one person to agree that it's that they're not convinced beyond a reasonable doubt is easier than 12 to agree. That's been my experience. I've had a number of hung juries, which doesn't move the ball any because
Right.
You're still in the same spot. It's a mistrial, and you have to do the whole thing again over. But sometimes it leads to getting the case worked out.
Yeah, I see that question kind of two ways. One is, the work that we do, defense and prosecution, trying to work cases out for pleas. I think it's easier to work those cases out amongst lawyers.
Yeah.
The other way I see that question, though, is do you want a bench trial in front of one judge?
Right.
Or do you want a jury trial in front of a jury? And I think almost every single time they choose jury trial because it comes down to factual disputes instead of just legal disputes.
Mm-hmm.
Now, you mentioned pleas. Now, obviously, in your circuit, the 15th Circuit, Horry and Georgetown County, you have thousands of cases on a yearly basis, but only have 26 weeks essentially in the year to be able to try all those thousands of cases. So because of that, most of them get pled out. Does the defense take advantage of the fact that you know that most cases are not going to go to court as far as trying to get a good deal for your clients?
I think it depends on the specific case and circumstances. Because if you've got the case where it's public enemy number one and the person has a target on his or her back, that's not going to help you, because somebody's going to be in the priority list. And if you're in the priority list, I don't care how many cases they have, yours is going. In the general sense, though, what you want, even in something like a traffic ticket case, or even a DUI, or even a serious case, when you call the prosecutor and say, well, what about, James Johnson? And he goes, who? When you talk to the police officer about even a speeding ticket, you go, what about Wendy Hill? And you go, who? That's what you want versus, oh yeah, we know that guy.
That's true.
And Josh, speaking of pleas, do you talk to the families of victims or the victim themselves, depending upon how severe it is, before you offer a plea to a defendant?
Absolutely. We're always communicating. We have a whole division of our office that does victim services, reaching out initially, sending letters, trying to get contact, letting them know. They don't have the ultimate decision about what happens with the case, but their input is so important in the handling of every case.
And I can imagine that's a pretty tough thing to do at times, is dealing with the victim's family, because they know they've been victimized or feel they have been. And if the case is not there, it's got to be a tough, difficult conversation with them.
Well, similar to what Greg was talking about, a defendant might be their first time in court. Almost all the time, the victims, it's their first time being involved in the justice system.
Right.
And they didn't choose it. They've been victimized, and this is the only case, and it's the case that matters to them.
Tell you what, let's run to the phone here real quick. If you have any questions about criminal law, today is the day to get those questions answered. A phone number is on your screen. Michael is in Myrtle Beach. Hi, Michael. Thanks for calling in today. What's your question for the panel?
Question is, I take care of a motel over here that my buddy's trying to sell, okay? So I'm the owning guy that does the security and maintenance here. And the local police force isn't really around to help me out very much. So I'm chasing my own burglars off, finding people breaking into rooms. So about December 13th, I'm going about my tour. I find somebody in the room. Well, I go down, I call the police. Lo and behold, they're not here like always. And I chase the guy down the block about 2 ways. So he gets away. I come back, the police still ain't on the scene. I go up in a room and there was a container there, an empty container, mind you. Empty meaning you can open it up, turn it upside down, and nothing falls out of it. I put it into my leather jacket because I keep things around here. It happened to be a fuse container. So about 9 days after that, they pull me over on my bicycle, take me to jail for not having lights on my bicycle. While they pat me down, searched me, they found this container that is empty, mind you, and they charged me for methamphetamine or cocaine base. Now, what can I do about this? There's nothing in this container. If they would have been there on the scene, they would have ended up finding the container. So it's on me because I'm head of security and maintenance over here, and they're going to charge me for something that was nothing in this container. What do I do about it?
Well, first they're going to have to prove that there was a substance. They're going to have it tested, even if it's a minute amount. It's going to have to be tested and shown. But I like your facts. I mean, you know, you've convinced me that that's what happened, and you would, you know, could convince a jury of the same thing, or convince a prosecutor that a jury may see it that way.
Anything to add?
The thing that I wondered is when he said there was nothing in it, I just wondered if it was one of these containers with a false bottom, and the police knew that, and they opened it, and there was something in it. Because, you know, Kirk's talking about trace amounts.
Right.
And we've all seen trace amounts there's cases on it where it's just trace amount. And that's sufficient in our court system. Some people have been convicted of trafficking drugs
Right.
based on trace amounts, and the other evidence, such as the phone calls, the records, the money seized, everything looking like a trafficking organization, but for the fact that, you know, the drugs were gone.
Right.
So in that situation, you know, what they have to prove on a possession case is they have to prove knowledge and intent. In other words, they have to prove that you knew you had the thing, and then they have to prove that it was your intention to have it. In other words, the words are dominion and control. So they have to prove knowledge and intent. The problem, though, is that there's an assumption that if something's in your car, if something, depending on the circumstances, there's something in your container, that you would know what it was. But the other part, too, is that, you know, people that are in his situation, he called the police. He tried to get the police to come.
Right.
I don't know if they ever came and filed a report or anything, but he would probably have said, yeah, I found this container in the room. But every case is fact specific, but I'd be interested to hear what Josh has to say about it as the person who will be prosecuting him.
Yeah, so I think, I mean, the fact that it was 9 days later comes into play. You know, like Greg was saying about the phone calls that you can help show your defense attorney that you made those calls, and that might have been where you got it. But when the police arrive, and finally arrive, maybe, but it's 9 days later, and all they do is they find you with that container that has a substance that's illegal,
Right.
And no one else has it, then that's a possession charge. And I
Right.
think that's going to get charged every time where someone is found in possession of an illegal substance, and no one else around has it,
Right.
no one else claims it.
All right, well, Michael, hopefully that helps you out. It sounds like a rough situation, but hopefully you'll be able to get out of that. We're going to have to run to a break here real quick, and when we get back, we'd like to take your phone calls. Criminal law is our topic here today on Legal Access, brought to you by the McGuire Law Firm. Welcome back to Legal Access, brought to you by the McGuire Law Firm. Criminal law is our topic here today. If you have any questions about drug arrest, DUI, any kind of traffic tickets, or just the court system in general, we're here to answer those questions here today from the solicitor's office. Josh Holford is here, along with defense attorneys Greg McCollum and Kirk Truslow. so we're well equipped to answer any of the questions you might have. I watch a lot of true crime TV because, well, I'm old, and I guess that's what you do when you get old. And I saw something here the other day where in Texas they allow what they call habitual bad acts to be brought in by the prosecution, even if there's something that hasn't been adjudicated. They're able to bring this in. It's kind of like an anti-character witness as far as the defendant is concerned. That's not something obviously that you can do in South Carolina, but do you think it's a good idea to be able, because the character witnesses can be brought in, from what I understand, to say why this person is good. Why can't somebody be brought in to say why this person is bad?
Dave, not only can they do it,
Oh, do they? Okay.
They try to do it all the time, and there are some pretty intense arguments about whether or not that is admissible. And it comes down to this thing, they call it Lyle evidence, which is prior bad acts. And the Lyle case said it's basically a signature. In other words, like if you're looking for a serial killer and he always leaves a little pink bow and a purple bunny at the scene,
Yeah.
and you find him with a pink bow and a purple bunny because he just left a place where you found somebody dead, you can use that. In the cases that had come out over the years, they would say something like, well, in that accusation, he ran. And so somebody ran in both circumstances, so that's similar. Or somebody was wearing, can you think of another one? Because I was going to say they were both wearing pants, but that's not actually one.
Yeah, it
But-
can be very damaging evidence too, and it's just, the bottom line is it's not a high threshold for them to be able
Yeah.
to use prior bad acts or prior bad
But the
crimes.
reason they want to use it is because it's so damning,
Right.
which is why it's not admissible historically. Because if you're on trial, you're supposed to be on trial for what they accused you of doing
Right.
that day, not some other day. So I'll be interested to get
Well,
Josh's
I've-
response.
I've had a case where there were 4 armed robberies and we had a trial on just one, and they brought in evidence of the other robberies.
Right.
Because they were similar, and that's an example where they used it in trial.
So I think, if the prejudicial effect substantially outweighs the probative value, then it's not going to be allowed. That's kind of the balancing act that a judge
Right.
does. But there are instances where you can use that type of evidence. You can use it to prove intent. You can use it to prove motive. You can use it to prove that the police weren't mistaken when they identified the individual. And you can use it if it's a habit. The habit one is a little more difficult to get to,
Right.
because you have to show repeated patterns that make that a habit. It can't just be one instance. But the Lyle evidence, there are cases on point that discuss that, and those issues are hotly contested in
I
court.
bet.
Yeah.
Well, that's why I asked the question, Greg, because I wasn't aware that you could do that. All right.
It's rampant.
Tell you what, let's go back to the phone. We do have Kristen on the line here from Little River. Hi, Kristen. Thanks for calling in today. What's your question for the panel?
Yes, hi. I am trying to seek what I can do. I was a victim of fraud. Nothing has been done. It was my information was stolen from my vehicle, and I was not here. It's been a case ongoing. I've had the police involved, the HOA with cameras. Bottom line short, it ended up being $10,000. Home Depot here let somebody just walk in and with no verification and buy a lawnmower, and I'm pretty sure I've done my own investigating, but I've been sent to a victim's advocate, but I'm pretty sure it's part of the lawn system here. It's just, I don't know what I can do. The police have been no help. They've tried to follow up. They sent me a victim's advocate. Is there any, recourse? It's destroyed my credit. It's caused a big thing, and I'm not getting much help here from the police or anything. Even there's cameras everywhere. These people basically got a hold of my card.
Right.
I was out of the country and charged up. All locally here.
Right.
Like, it started out with $1,500. Walmart here, all these gas stations. And by the time I got it done, it was just, they ended up getting into a buying stuff it just
Right.
went crazy. But
All right,
I've
Kristen,
not
is
had
there
any
anything
help.
that from this point that she can do?
Hopefully, one thing that jumps in my mind is dealing with the creditors and not being liable for that money, because these companies can be fairly decent about that when you've gone to the police and you've made a report of what happened. And that should help you with the financial part of it, hopefully. Had you not gone to the police and done a report, the companies that were charged against probably wouldn't give you the time of day. And I'm assuming that the person was not identified or arrested. And that can be tough sometimes because they got nobody to prosecute yet. If you determine who it was or you think it was and have some video evidence, share that with them. But other than that, that's all I can think of.
Yeah, I mean, being the victim of a crime is so upsetting, and it really does. It can ruin your credit. It can ruin a lot of things in your life. But the police are investigating, but like Kirk said, unless they have a person that they can identify, then there can't be an arrest made, there can't be charges, and then that person can't be held responsible. And so it's all about identifying that individual. Unfortunately, most of the fraud these days is done online, on telephone, where they don't know who the person is. Maybe they're in a different state, maybe they're overseas. It doesn't sound like that's the case in this one, but they still have to be able to identify who the individual was who took your information.
All right, Kristen, well, good luck in your request, and hopefully things work out in your favor. We're going to have to run to a break here real quick. When we get back, we'd love to take your phone calls. The number is on your screen. We're talking about criminal law here today. That's our topic on Legal Access, brought to you by the McGuire Law Firm. Welcome back. It's Legal Access, brought to you by the McGuire Law Firm. Today's topic is criminal law. If you have any questions about drug or DUI arrest or the court system in general, please feel free to give us a call. We'll answer those questions for you here today. Only got about 10 minutes left, though, in the show, so don't wait till the last minute, because it's already the last minute. Give us a call. Numbers on your screen. All right, what do you guys think? I mean, what is the funniest part if you watch a crime show on TV whenever the criminals get to court? What's the funniest part about seeing court system on TV?
The timing.
The time.
Yeah, it's got to be the timing. I mean, they wrap everything up in an hour show like it was a week. And unfortunately, it's just not that way. I've got clients that have charges hanging over their heads for years trying to get them resolved. There's just a lot of cases.
For us, it's the testing. The fingerprints, the DNA, it's everywhere and on everything.
Oh, yeah.
You're going to know, within 30 minutes whether it's Dave's DNA on that desk or not. And that's just not the case. I mean, that stuff goes off to a scientific lab, and it takes months and sometimes years to get that returned.
And so you're allowed to talk back and forth with the judge and be smart aleck to them as well?
No.
Not like on TV?
That doesn't happen either.
I think the biggest thing that jumps out at me is when they get the scientific test and there's a result. So like if it's a DNA match and a real DNA test, I mean, it's basically a written report where they're describing what happened. Fingerprints, somebody says it's a match, but you just have the fingerprints and you can look at them and they've got the points. But on the show, what they have is they have a screen and they look down and it turns green and it's a square and it says match.
Yeah.
Matching is a scientific opinion. There's nothing that says it's a match. We're saying it's a match, but there's no handheld device, right, that says match.
Yeah, I mean, the DNA even will say, they won't say it definitely is, they'll say it's 1 in 100 trillion, probability that it is.
Mm-hmm.
Now, Josh, from a prosecution standpoint, I know that you take advantage of diversion programs, or at least a lot of the defendants take advantage of diversion programs. Does that work well for your office?
Absolutely. First-time offenders, diversion program like a PTI is useful. It keeps their record clean, and those are the people that aren't going to reoffend. And so it's an excellent program. A drug court, treatment courts, mental health courts, those are things that really are changing lives and making sure that people don't reoffend. That's the ultimate goal. We don't want them to continue to commit crimes, to victimize people in the community, and I think they're excellent programs.
Along those lines, if you take somebody, and first of all, we have this idea in our society that we're infallible. And we look at it like, okay, you lived this many years, this many months, this many days, this many hours, and for those 10 minutes you did something stupid. But then we look at it, and that encompasses your whole life. And so what Josh is saying, and I agree with, is like people make mistakes. They do dumb things, sometimes they do bad things, but once you stigmatize them, once you give them a felony conviction, you've handicapped them. And so a lot of times they can't get jobs, they can't do this, they can't do that. And so it makes sense to take somebody who's never going to offend again and give them a chance, a second chance in life, because we all benefit. And there were cases when I was a prosecutor when sometimes we were like, okay, catch you later. You know, if we dismissed a petty drug dealing case because we had grounds and they reoffended, well, we got you anyway. So that's now that you blew your second chance. And that's, I firmly believe in that, is that, you know, I believe that, I mean, we say we're a country, you know, of forgiveness, or you can improve your life, and that's just an instance of it.
And those things like treatment court, I mean, they're not a cakewalk. Those people in treatment court are working hard to get through there successfully. There are a lot of requirements that they have to get through it.
As long as we're talking about substances, usually if I have defense attorneys here, if we get to DUI, okay, if somebody comes up to you at a party and says, okay, if I get popped for DUI, should I blow breathalyzer or not? What's your guys' opinion? What do you tell people if they ask you that?
Well, if somebody's had one drink, I would take the test, I think. Although those machines are fallible and it could lead to a wrong, improper result. I mean, it could. But otherwise, if you don't give the sample, there's a vital piece of evidence that's missing from the case, and you have the right not to give that. However, there are some other civil implications that will get you. You can get a license restriction, suspension for that, for refusing. But it may help your criminal case tremendously.
Right.
I asked Kirk that question one time. I said, "Listen, well, first of all, I won't drive after drinking half a glass of wine, because I'm not going to do it." Okay, and I told him that one time. I said, "Well, you know, if I had a glass of wine or something with dinner and then ate something and then I got pulled over, I said I'd take the test because I'd be below the limit." And he reacted and said, "Why would you take that test? You've seen those results. What are you going to do if you come back and you got a 20? No one would ever believe you. Why would you ever take that test?"
Yeah, I said that.
And Josh, from a prosecution standpoint, how important is breathalyzer results?
It's an important piece of evidence that's used in DUI prosecutions. It's not the only piece. There are videos, there's how they're acting, how they look on the video, are they able to do the standard field sobriety test, those things. You can definitely prosecute a case if they don't blow into the machine, but it is an important piece both ways. If they do blow and it's below the inference level, then that's going to help resolve the case in not a DUI. But if they do blow and it's above the level, then that's going to help prosecute the case for a DUI.
All right, well, thanks for watching today. We've been talking about criminal law. If you have any further questions, you can email us and we'll answer you off the air. It's legalaccess@WMBFnews.com. Next week when we get together, we're going to be talking about automobile accidents. I want to thank our panel here today from the Solicitor's Office, Josh Alford, also defense attorneys Greg McCollum and Kirk Truslow. I'm Dave Priest. Automobile accidents, that's our show next week right here on Legal Access.
You may wish to consult a lawyer to obtain case-specific legal advice. Information regarding lawyers can be located online or by contacting the South Carolina Bar Lawyer Referral Service, toll-free at 1-800-868-2284. If you are currently represented by an attorney, you should direct all legal questions to your attorney. The nature of any legal issue may depend on